President Trump, they write, respectfully submits this second removal notice. Why? Because the zombie case should have been dismissed a long time ago. The ongoing proceedings will continue to cause direct and irreparable harm to Trump, the leading candidate in 2024, as Justice Merchan has maintained a post-trial gag order that restricts Trump from engaging in political advocacy based on valid criticisms of New York. And an entirely unjust sentencing is currently scheduled to occur on September 18th. That could result in Trump's immediate and unconstitutional incarceration and prevent him from continuing his groundbreaking campaign. President Trump is seeking to remove his case from Judge Merchan right as sentencing comes around the corner. You can see this was filed in the United States District Court for the Southern District of New York. This is Trump's second attempt to take this case away from Alvin Bragg's prosecution in the state level court. Right now, we know that Judge Merchan, who is presiding over this trial, has a very interesting conflict of interest because his daughter, Lauren Merchan, worked for Kamala Harris, and that organization called Authentic Campaigns raised a bunch of money off of the Trump prosecutions. And so Trump now is trying to take this away from them because they're not honoring the law. First of all, they're not honoring their conflict, but they're also not honoring immunity. And so Trump submitted this. You can see there's some good stuff inside. President Trump, they write, respectfully submits this second removal notice. Why? Because the zombie case should have been dismissed a long time ago. The Manhattan Attorney's Office violated President Trump's immunity and the immunity doctrine during their grand jury proceedings and again during the first term in office, saying the Supreme Court recently ruled that these types of violations threaten the structure of the federal government and the ability of future presidents to carry out their vital duties in the way the framers intended. Bragg's flawed case is also preempted because the indictment was on the improper use of state law to try to retroactively police another 2016 election through non-unanimous jury findings. They say the Supremacy Clause violations also come from Bragg's overreach, are illustrated by the fact that neither are federal prosecutors nor the FEC ever prosecuted Trump in the first place. So in other words, Bragg is acting like a federal prosecutor. He's prosecuting federal issues at a state level. So they say this all has to go. The Supremacy Clause is not the only provision of the Constitution that Alvin Bragg is ignoring in his purely political New York prosecution. The ongoing proceedings will continue to cause direct and irreparable harm to Trump, the leading candidate in 2024, and voters way beyond Manhattan. The harm includes First Amendment violations, as Justice Merchan has maintained a post-trial gag order that restricts Trump from engaging in political advocacy based on valid criticisms of New York. And an entirely unjust sentencing is currently scheduled to occur on September 18th. That could result in Trump's immediate and unconstitutional incarceration and prevent him from continuing his groundbreaking campaign. Since this court remanded the proceedings in connection with Trump's first removal, so Trump already tried to take this up to federal court and they already sent it down. They say a lot has happened. This is why we're back. 3 intervening Supreme Court decisions added force to his federal defenses based on immunity and preemption. In an opinion that became final less than 30 days ago, the Supreme Court came out and said that Trump does have immunity from criminal prosecution for official acts, and relevant here that prosecutors may not use official acts evidence in connection with the prosecution that they claim arises from unofficial conduct. So if they say Trump did something bad, okay, then prosecute him on the bad things. You don't also get to prosecute him on the immune things or use immune things in the prosecution of the bad things. In Trump versus Anderson, another case, the Supreme Court warned that states' power over governance does not extend to federal candidates. The Supreme Court also overruled Chevron, which required deference to agency interpretations and implored the courts to rely on their core interpretive competencies when interpreting statutes. Don't default to the agency decision. Anderson and Raimondo abrogated prior decisions that deferred to the FEC's restrictive interpretation of preemption, which applies broadly to any provision of state law with respect to the FEC. And so therefore that voids the New York laws that Bragg applied to 2016 to try to manufacture non-existent crimes. So Chevron also comes into play. Now, in addition to those binding precedents, removal of the federal court is also necessary because Alvin Bragg created a trial record that is inconsistent with what they made in their representations to this court. Okay, so they tried to remove the case before the trial. Bragg said, no, your honors, don't take this case from state court to federal court. Here's what I'm going to do at the lower level courts. This is why it's appropriate. They say, well, we watched what you did, and what you did didn't match what you said you were going to do. They say, for example, at a June 27th hearing, Bragg told this court that there could be no argument by President Trump Trump that anybody involved in their baseless allegations was doing anything in carrying out their job as a government actor. That's not true at all. At trial, Bragg violated that representation and the presidential immunity doctrine by offering literal evidence of Trump's official acts. So Bragg went to the federal court and said, you are not going to hear anything about immunity at all. Nothing about anybody being a government actor in any way. No official business coming out. Turns out at trial, they literally introduced official business. So for the purposes of removal, the court must credit, and Bragg cannot dispute, that Trump's defense theory that prosecutors relied on official acts evidence at trial and in grand jury proceedings. We now know they're literally using official acts evidence everywhere. Bragg's official acts evidence included, for example, stuff we bring up all the time, testimony from the White House comms director. That's Hope Hicks. She testified literally at trial about confidential conversations she had with President Trump in the Oval Office. Official. Bragg relied on testimony from another aide called Madeleine Westerhout, whose desk was located immediately next to the Oval Office, about her observations of Trump and his practices as president, and how he handled sensitive matters, and how he handled national security issues, including on the phones. Bragg also offered evidence of Trump's official public statements via Twitter and official financial disclosures that he made as president pursuant to the requirement of a federal agency housed in the executive branch he was running at the time. And lastly, Bragg star witness and serial perjurer Michael Cohen testified about Trump's official response to federal investigations he oversaw. He also included testimony about a conversation between Jeff Sessions, AG, and Trump's pardon power. Bragg relied on all of this to present to a grand jury and violated presidential immunity. Now, as to preemption, that the federal courts preempt Bragg's case, Bragg told this court with the first removal the first time we were here that the charges don't relate to federal law. He's like, no, they don't relate to federal law at all. So it's a state issue. But the trial revealed, however, that's not true. Bragg's theory turned on whether there had been violations of the FECA about campaign contributions. Bragg requested, and the judge even gave them, watered down instructions about these complex concepts that required the jurors to moonlight as FEC commissioners, right? And they wouldn't even allow them to bring in the FEC expert to come in and talk about any of this. Despite having told this court that use of a special verdict form could mitigate the preemption problems President Trump identified, Bragg opposed Trump's request at trial for special interrogatories that would have required jurors to make unanimous findings related to those issues. They just muddied it up. Now, as to that request, Judge Merchan once again followed Bragg's lead, did not require unanimity. And remember, we spent a lot of time saying it was a choose your adventure type of prosecution, right? Choose your story or pick a card, any card. You can pick the elements of the offense you want. Just get enough of them. Go out there, just capture enough of the elements, and that's good enough. They didn't even have to be unanimous as to those elements. Judge Merchan also refused to allow Trump to assist the jurors in applying the FECA law by precluding expert testimony who was going to come in and explain this. Instead, they violated the Supremacy Clause. They said this wasn't about federal laws, but it was. Justice Merchan asked the jurors to consider on their own, among other things, whether those payments were made for the purpose of influencing an election. That is exactly what FECA preempts. That is why this should be in federal court. They say post-trial removal. Yeah, the trial's over, but you still need to take this case so that Trump can have an unbiased forum free from local hostilities where he can redress these constitutional violations. This is not an infringement on state sovereignty. This contemplates enforcement of a state law in federal court pursuant to federal procedures and subject to federal defenses. Trump's post-trial motion is currently pending. It's a motion to dismiss this entire indictment. Why? Because Judge Merchan is facing conflicts of interests and appearances of impropriety. He's already forecast his intention to deny the motion and direct the parties to prepare for sentencing in a couple weeks. Now, this month, President Trump renewed prior requests for Judge Merchan's recusal. Why? His daughter indicated that the judge had been critical of Trump's Twitter use. He said, I can't believe he posts on there, something like that. To her, she talked about it on a podcast. The problem with Justice Merchan's earlier statements is they confirm his bias. They confirm his hostility towards Trump's 2018 tweets, which were a core issue in the trial. But Judge Merchan denied the recusal motion without even addressing that issue. He claimed incorrectly that there was nothing new about the recusal motion, despite the fact that the motion connected evidence of a specific form of judicial bias to Trump's immunity arguments. Now, during the same period in 2019, the judge's daughter worked for the presidential campaign of Kamala Harris. She's now President Trump's main opponent. Justice Merchan's daughter took a senior executive position and partial ownership of Authentic Campaigns, which is a top campaign vendor with clients like Kamala Harris and Joe Biden, and other opponents and adversaries of Trump like Shifty Schiff censured. In 2020, Merchan also made improper contributions to Democrat interests. The judge donated to Biden for president and to Stop Republicans, which violated New York ethical rules, but they didn't care about it. Under the leadership of Merchan's daughter, Authentic has given services to clients, and they've actually solicited political contributions based on developments in the proceedings. They say Trump got arraigned in New York. Trump got indicted in New York. Send us some money to save America. Since Bragg charged Trump in 2023, Authentic has received tens of millions of dollars from those solicitations. Now, faced with these facts, backed by public FEC filings and social media posts, Justice Merchan has characterized the conflicts and the appearances of impropriety as just speculative. Oh, you're just making stuff up. Those are just based on rumors. Making matters worse, Merchan has insisted on maintaining a gag order on Trump that is unconstitutional, prevents Trump from even addressing these issues. Kamala can attack him. Tim Walz can attack him. Hochul can attack him, but he can't respond. Merchan continues to violate Trump's First Amendment rights, despite the fact that Trump would only be commenting on issues he's already raised in public court filings. And even though extrajudicial statements by Trump could not possibly impact the integrity of the remaining proceedings here, there are no jurors or witnesses at all, the continued operation of this unlawful prior restraint is causing irreparable First Amendment harm to Trump and to us, the American people. And it operates as a wholly inappropriate muzzle on the leading candidate in the election while he is on the campaign trail and during any debate with Harris. The first debate is currently scheduled, and he can't even talk about it. Justice Merchan has indicated he plans to decide Trump's presidential immunity motion on September 16th. Despite his documented bias relating to one of the forms of official acts evidence, and he's going to potentially sentence Trump just 2 days later on the 18th, which we'll be streaming all day on that, so thank you for subscribing. Now, at that potential sentencing, President Trump faces the prospect of immediate and unlawful incarceration under New York law, which could prevent him from continuing to pursue his leading campaign for presidency. Nor does Merchan in his current schedule allow Trump adequate time for an appeal, right? So if Trump goes in on the 16th, they say, you have no immunity in this trial. There's not enough time before he has to come back on the 18th for the higher level court to step in. Merchan has not ruled on Trump's request to adjourn sentencing until after the election so that election interference appeals can be avoided. Finally, the timing and the content of this second removal notice are supported by good cause. In the alternative, Trump should be permitted to amend the first removal notice if you don't want to accept this. The groundbreaking presidential immunity issues arising from Trump versus United States on immunity are alone a sufficient basis to grant this, but also Chevron are too. Now, as noted, additional removal litigation is warranted because here at the New York County trial this year, Bragg relied on evidence and legal theories that were materially different from the representations and arguments he told you last year. He lied to you. The record of those proceedings reveals the type of political bias, the conflict of interest, the appearances of impropriety that have animated the need for federal removal for centuries. New York procedures have proven so inadequate to protect federal interests, and allowing the New York County proceedings to continue unabated will result in further irreparable harm to President Trump, to the American people, and the presidency. And so these ongoing harms must be stopped. The impending election cannot be redone. The currently unaddressed harm to the presidency resulting from this improper prosecution will adversely impact the operations of the federal government for generations. And so accordingly, President Trump respectfully requests that the court accept this second removal notice, confirm that Merchan may not sentence President Trump during litigation over this second removal notice because sentencing would result in a prohibited judgment of conviction under U.S. Code, and order the case removed, notify Merchan of the removal, and set a motion schedule so that President Trump can seek dismissal of this case and a vacatur of the New York County jury's unsupported verdicts submitted by President Trump's defense team. That is the summary of this. You see, in conclusion, they tell us that for the foregoing reasons, Trump respectfully requests the court promptly order this case removed, confirm Judge Merchan may not sentence Trump during this period, and once the case is removed, set a schedule so that Trump can seek a dismissal of this case in this court. Signed by Todd Blanche, Emil Bove, defense attorneys for President Trump. So this is a little bit of a scramble. We're in the last minute final stages of this process. Trump recognizes that he's got a real risk here. On the 16th, the judge can come out, deny his immunity. He'll appeal immediately. We have the 17th day, then we come back for sentencing. As we know, if on sentencing day, the judge sentences him to incarceration, he goes into custody that day. And there's a bunch of articles. It's hard to tell what's true or not about them preparing for that, right? Them creating jail cells and everybody's trying to figure out what they're going to do if that ultimately happens. Now, I'm still skeptical about that. I have a feeling that that's going to be a little bit too much for them to bite off here. And I think the judge is going to look for some sort of an excuse to kick the can down the road. Khan may not want to have it seem as though he made a decision to kick it down the road, but if the federal government comes in, if the federal courts come in and remove this, he'll be relieved. Ooh, thank gosh. So he doesn't have to make a decision on this and potentially incarcerate Trump, because as much as they want to stop and eliminate Trump, I don't know that incarcerating Trump serves their purposes. I think it would just exacerbate, and honestly, I think it would make real a lot of the concerns that Trump has been talking about, right? Trump has been saying he's been being politically prosecuted for years now. A lot of people scoff at that. Even Nicole Shanahan was scoffing at that. They try to incarcerate him for this Michael Cohen case. Every single point that he's made will be vindicated, and I think that there will be a very serious movement to reverse what they've done there, and we'll, of course, be hopeful that they don't go that far, but we'll be here covering it to see.